His name's Edwin. He does a lot of the legal document creation and transcribing these documents. He's a lawyer himself as well. So again, he understands the legislation and how we can help. So Edwin is here with me on the presentation, but just as everyone's coming in, feel free to put any questions you might have in the chat box or the Q&A today. Again, we will be answering those throughout the session. And then for all webinar attendees who are here today, there is a special offer that we've got going on our essentials and our legal advice plan. So definitely stick around to the end of the webinar. So again, just going through today's agenda and what we'll be covering, we'll be looking at how to make the most out of our documents. So perhaps you've recently signed up for a free account or you're currently an essentials plan user. We'll show you how to maximize your usage out of the template library. We'll go through some expert tips from Edwin. So using the document library and the document builder, there'll be some power tips on how you can get the most out of these documents using e-signature and all the hidden tips and tricks. We'll be going through ensuring compliance with the formal requirements of your documents. So again, how you can stay compliant with your legal documentation. And then lastly, staying informed about upcoming documents. So again, we do have requests every month for new documents that we take on board, and Edwin will fill you in with those. So again, lastly, if you have any ideas for document improvements or any specific requests, we'll leave that to the end and we'll do a Q&A time. So without further ado, I'll introduce Edwin to the stage to kick off today's presentation.
Sorry, just really briefly, I think this should be a good time for everyone to have a bit of input through the form of the poll that we prepared. So should we bring that up now? All right, great. So let's give participants a couple of minutes and then we'll read out the results. We'll just give it another 30 seconds or so. Alrighty, we're closing that, and I'm going to have a look over the results now. So it looks like in terms of the biggest focuses for companies that are present here today, we had efficiency, customer experience, and sales and marketing, as well as legal being the forerunners. In terms of industries that are present, we have a fair few people from consulting here, as well as accounting. We have a few startups and also some agencies and construction companies. So yeah, number 3 is kind of why we exist. A lot of people don't have lawyers, don't ever have lawyers, but still require the legal needs met. So we actually have about 40% of people who answered question 3 have had a lawyer, and of those, half say that they're not getting the right advice. So yeah, hopefully that's something that we can talk about this presentation goes on. Looks like we have quite a few Lawpath customers present. So those already subscribed are familiar with how the product works. But a big part of the purpose of this webinar is not just to show the different features of product, but also to show certain aspects of it that may not be obvious even for subscribers. And we have a range of companies in terms of how long they've been around for. So half of the companies that answered have been around for more than 2 years, and then a quarter have been around for between 1 and 2 years, and the remaining quarter have been around for less than a year. And in terms of the biggest document issues that came up, we had 2 that were pretty clearly problems for a lot of people, which is that the document didn't suit their needs and that they lacked sufficient information about the subject or the matter at hand. So those are 2 things that we'll cover throughout the presentation. You may have had other issues as well, and there'll be time for you to talk about those at the end. So without any further ado, let me launch into the presentation. Okay, what do I need to know to make a good document for my business? So our questionnaires function like workflows, which is a separate part of the website that you may be familiar with. What I mean here is that every single question matters, and the importance of each question may not be apparent at first. We make it apparent through a range of ways, but it's important to make sure that you're paying attention to particularly what's being asked of you and not overlook any particular aspect. So the way that questionnaires are normally structured is in 4 general parts. Firstly, you have the party details, which is the name of the party, be they company, individual, trust, partnership, and so on. Their address, some of their contact information as well. Then you have details about the transaction or specification. So what's actually happening, what are the names of the products or the trademarks, what are the industry standards that parties expect to be adhered to. And then we have legal terms, which are the terms and conditions of each document. So this is what some lawyers would call boilerplate, but it actually encompasses a bit more than that. And though some of these terms may not seem that relevant to you at first, they are very important in preventing problems later on. And finally, we come to the signature block. So the reason I'm going through these is because that's generally the order in which we put them in questionnaire. That's not necessarily the order in which they appear in the document from top to bottom. And sometimes people find this to be a bit of an issue, but we structure the questionnaire in that way in order to create a logical flow and allow people to start off by putting general information into the document and then moving towards the more specific. So I'm also highlighting this because we generally encourage users to go through the whole questionnaire before clicking on the yellow dynamic fields within the document, while we provide the ability to directly edit the document through those dynamic fields or through the free text. Clicking on those fields may change the order of the questions that you answer document in. So you may unwittingly skip some questions by doing so. However, we also have a feature whereby the questionnaire will tell you at the end if you've missed any questions, so you'll then be able to go back and check everything. All right, part of the reason why I brought up I did the questionnaire is a little bit like a workflow, is that the questionnaire highlights areas where more information gathering may be required. So if you are unable to provide the information necessary to answer a question, then this may be an indication that you're not ready to complete the document. I know I sound like a bit of a lawyer when I say that, which I am, but yeah, it's important to know that these are not just tasks to complete, but it's also important to get an indication of whether this is the right thing for your business to be doing, or whether you have sufficiently discussed a matter with another party before coming to the agreement. And that is what some of these questions will indicate. And to illustrate that, I'm now going to share my screen. Thank you, Ryan. I'll just be are we sharing that?
Edwin, did you want to share your screen? Did you mention?
Yes, so I'll just do that myself.
Yes, just click on share screen and your co-host now. Yeah.
All right, got it. So this is the contractor agreement. And I've sort of started the questionnaire about a third of the way through, just to illustrate what this particular section of it requires of you. So how long does the hire have to pay an invoice received from the contractor? This is obviously a matter of the policy of the contractor themselves or the agreement of the parties. And then you get to specific questions that have real bearing on the document, like will the contractor be using the hire's facilities, which is something that's important for the parties to discuss. And then, yeah, here there is the space for those facilities to be enumerated in greater detail. And now we come to a part where, yeah, some users may be stuck, but as I said, this may be for good reason, because this is telling you if you're stuck, then you need to go back and think about these particular issues. So that's in regards to insurance. In many situations, insurance is required by law. We're not able to cover all of those situations in this document. However, our questionnaire here highlights that these may be issues that you may want to discuss. And as you can see, every time you click yes, it asks you to provide further information. Okay, so now returning to the presentation. So it's really important that in order to ensure that you have the right document and you know how to use it, that you look at the document summary. This should, in every event, be your first point of call, as it highlights how documents must be signed and any post-execution steps required, where you can and can't edit documents. So although some documents that are very much prescribed by legislation, like statutory declarations, may allow you in the document builder to make changes. We make it clear in the summary that this is not recommended, because if you deviate from the prescribed form, then it may not be valid. We also highlight other useful documents, and in having that information, it may help you to realize whether you have the right document or not, or whether there may be another one that's more suitable to your purposes, as well as circumstances where you might need legal advice to complete a document, which we very much highlight. So next slide. All right, so this is what the document summary looks like. I'm sure many of you have seen this page already. It's accessed by clicking the title of the document after having found it through the document search function. So this has some of the features that I highlighted before. It says at the very top that you must seek legal advice from a qualified professional before using this deed to check that it meets your specific circumstances. As well as highlighting that it's important to understand the state and territory laws regarding stamping and lodging your deed. So although in an ideal world, these documents will be designed as a kind of one size fits all, that's not necessarily what the legislation allows. And of course, there's a whole range of circumstances that we try to cover, which is why we have so many different documents on our website. I think also some users looking at this page sometimes may may ignore some of the information because sometimes there's, for instance, just lists of what the document includes or relevant documents, and you may already be familiar with that. I encourage you to make sure that you're not missing any important information just because you're overlooking those aspects. So I'll let you know a little secret. To deal with this page, the reason why sometimes it contains a lot of information is because it both faces outwardly to non-subscribers, and also it's on the platform for subscribers to know how to use the document. But stemming from those purposes, we do try to provide as much functional information about how to navigate the document to make sure that you know that it's the right document, and that you are aware of the extent to which you can edit it without legal advice. To the main considerations. Okay, next slide, please. Besides the document summary, the biggest way that we try to assist our users is through presenting tips and common answers that directly attach to certain questions within the document. Now, these differ a little bit in the kind of information they provide. So in the first example, for understanding a document, now this is from a services agreement. What the tip here tells you is that when the service is less than 100,000, the agreement will contain provisions that limit the liability of the supplier. This isn't a figure that we've just pulled out of thin air. It's actually part of the Australian consumer law that when the service is provided for more than 100,000, there have to be certain, the liability of the supplier will persist regardless of any provisions that speak to the contrary. So that's applied to the document by legislation. So yeah, that sort of gives you a sense for what happens when you click yes in that example. Secondly, we put that information there to help you make sound commercial choices. So in this example, it may be that you haven't thought about the intellectual property that is being handed over in the context of providing the services within the contractor agreement. However, if you're dealing with some kind of like artistic interpretation of the client's subject matter, such as through graphic or web design, then there are going to be intellectual property issues that come into play. And the tips and common answers explain some of the implications of that. So with our particular clause, the party's IP that's developed independently of the project remains our own, and any IP developed within this project becomes the property of the contractor. Now, the final example is for instances where the choices that are being made and answers that we provided are primarily strategic, commercial in nature, really up to you in terms of what your business values and what you're doing with this document. However, we do provide some intelligence about what best practice may be in a certain industry, what may be common practice from like a corporate perspective, as in this case, the tip here explains what a drag along ride is, but then we also tell you that it's commonly between 50% and 90%. This is in the context of our shareholders agreement. Now, we also have another question in our shareholders agreement, which is what is the maximum number of directors that the company may have? And there we not only explain that the typical number for Australian businesses is between 3 and 7, and an odd number so that there's always a numerical majority. We also provide common answers, which means that if you want to save time, you can just click on the number, whether it be 3, 5, or 7, just to make your navigation a little easier. So that's how we provide that level of intelligence. All right, next slide, please. It's important to remember that none of the information that we provide is legal advice unless we say that we're giving legal advice, which is generally in the context of the legal access plan. You might have seen this already in the form of a disclaimer at various parts of the website. And I want to make sure that you all understand exactly what it means. So legal advice is effectively us listening to your problem and telling you how the law applies to that problem. That's a very broad brush definition, but that's the crux of it. And I guess it also entails a certain level of trust that wouldn't exist outside of a legal relationship. Now, the reason why we say that it's not legal advice is because although all the information that we put out there is generally, we've done all our research and we've had a lot of appointments with our subscribers on various legal issues, and from that we've gathered what the best clauses are to fit their purposes, and we've made those clauses customizable. That doesn't necessarily mean that those clauses are the most appropriate to their circumstances. In order to be sure of that, the next step, which we encourage some subscribers to take, is to seek a lawyer through the marketplace or the LAP. So yeah, that's not just for our benefit. It's not just so that we're covering ourselves in terms of liability or something like that. It's also so that you know that even though we've put a lot of reliable information out there that we regularly update, whether you're using the right information depends on how the question is posed, on what your needs are. And this should all be considered in terms of a conversation with a lawyer, especially when your needs are particularly complex. But this is something that we take into consideration when drafting documents. And so either when starting a document or when coming across certain questions within a document, we make it clear that it's important to seek legal advice in certain areas. Next slide, please. Okay, this is where we go a little bit more into the weeds of the mistakes that people make when drafting documents from a technical perspective. Next slide, please. All right, first of all, I want to just give a few quick tips to help you find the right document, as that was one of the issues that was listed in the answers to the questions as to what issues people found with documents. So first one, some people may be confused by the specific label attached to the document, whether it's an agreement or a contract, and they may start looking for the similarities and differences between agreements and contracts that they've used in the past. I just want to make clear that there is no difference between an agreement and a contract. From a legal perspective, from a semantic perspective, sometimes those words are used slightly differently. You may talk about something, an agreement being non-binding, but in general, when we talk about agreements and contracts, we talk about binding agreements. And that's something that's made clear in all of our documents. It's also important for you to understand that sometimes we change the names of documents for SEO purposes. There are some documents on our platform that have quite similar names or the same name. Quite similar names or quite different names that are actually in substance the same document. But what we're doing there is we're helping people find those documents on the basis of the sorts of things that they're likely to search. The document description and summaries will help you identify the right documents. So this links back to what I said before about document descriptions containing important information about when some documents should and shouldn't be used, the jurisdictions that they should or shouldn't be used in, when they should and shouldn't be e-signed, which is something that I'll get into as well as the range of alternative documents that may be available to you. Yeah, and finally, as I mentioned, jurisdiction is very important. We specify in what jurisdictions certain documents can or can't be used. This is already within the document summary page. Next slide, please. All right. Did I break my document? What do I mean by break? I mean that for some users, they seem to come across a glitch or a technical error that results in your document disappearing, or an error message coming up about deleting dynamic fields, or finding that your answers seem to have no effect on the document, which can be a little bit confusing. And finally, that your text may be duplicated. So sometimes this is our fault. Sometimes there are genuine technical errors within the document, and please let us know when you come across those. A lot of the time, it is because of the way users approach formatting within these dynamic fields. And to illustrate this, I'm going to share my screen once again. Right. All right, so here we have the business sale agreement. Now, there's many things I can do here that will make this agreement very difficult to use. For instance, if I start introducing spaces in between these fields, it treats it as two different fields. And the result is that we get 3 different dates. And obviously that's going to create a problem. This is something that can generally be resolved just by pressing Ctrl-Z or undoing that move, or pressing the undo button up here. Another mistake that users made is deleting this field altogether, and then you will get this error message up here. So once that happens, the date doesn't come up anyway. And this is a problem because generally, to ensure the validity of signing, and sometimes according to legislation, documents should be dated properly. Sometimes people will copy clauses from one part of the document, including formatting, and attempt to paste them into dynamic fields. And sometimes this works, as you can see here, simply by removing the space that was in those 2 lines. Sometimes it just doesn't work. Sometimes it creates a mess. What we encourage users to do, if they do want to customize the document, which is often a very legitimate user document, is to go through the questionnaire from the beginning all the way to the end in order before making changes to the document. And this will let you know the things that you need to, the information you need to gather, the matters you need to consider in order to be able to complete the document. And it will also let you know how the questionnaire interacts with the document, so that by making those changes, you're not accidentally deleting fields. So yeah, once you're done with the questionnaire, before clicking submit, which will take you to the next page, that's a point where you should consider making manual changes to the document, if that's something that you feel is necessary. Also, a concern that I want to address is that sometimes you may have seen that certain buttons or certain questions do not impact the document in any way. That might be because the field to which that question corresponds is part of a clause that hasn't been inserted already. And this may simply be the next question. So yeah, going through the document, through the questionnaire in order will help you make sure that you don't stumble with any of those issues. All right, now let's get back to the slides. Thanks, Ryan. Okay, now let's get to the meaty part of the presentation. This is about ensuring that your documents are legally binding. All right, next slide, please. So this is a huge concern of mine. And we've gotten some queries that, though it may not be apparent at first, can be resolved by by understanding, just who the parties are and who should be signing. So the parties to agreement are the ones who will be bound by the terms of the agreement to each other. They're not necessarily the individuals who are going to perform the agreement. They're not necessarily the individuals who are going to sign the agreement. And I'll illustrate this through looking at a non-disclosure agreement, which is one of our most commonly used documents. So generally, individuals sign, and predominantly it is individuals who are restricted from releasing information under a non-disclosure or a confidentiality agreement. However, in many cases, the parties who are bound by the document will be companies. So how do these things relate to each other? Well, it is the companies who are the parties. It is their representatives who sign. And when you have a company being a party through the representative signing, there is a prescribed form of signature that needs to be implemented for that. Now, you may ask, what about all the employees of the company who also need to keep their mouth shut in regards to certain IP? Well, that's not necessarily covered in the document. Sometimes there are terms that relate to the responsibilities of the company's employees, but for those employees to be bound, the company will make separate NDAs with them, if that makes sense. Whereas the main NDA may be between two companies binding each other. So this is different to having two individuals who are not companies, who are making a non-disclosure agreement and who may be signing on their own behalf, as opposed to signing as representatives of a company. It's also important to note that certain agreement terms are one-to-many. For instance, our services agreements applied to a customer actually functions as the terms and conditions. Sorry. So although it may not be clear immediately who the parties are, that's because, as we explain in the description, this is an agreement that is incorporated into a further agreement between a company and a customer. So yeah, I hope that's clear. It seems from a customer's experiences in the vast majority of cases, it is companies who sign documents. And so I hope the distinction is clear between the companies who are bound, the representatives who are signing a document, and then the individuals who may be bound by those companies to fulfill the obligations under the main agreement. Next slide, please. All right, so this feeds into the really important question of each document, which determines whether it's binding or not for a court, which is how do companies sign documents? So the Corporations Act provides two methods. Section 127 execution or signing, which involves directors, and Section 126 signing, which involves authorized representatives. Now, whether a document can be signed through Section 126 or 127 is actually up to us. We don't generally provide that option to our users. The difference being that Section 127 execution is quite customary for a lot of documents, especially corporate transactions, and it's more formal and provides more evidence that it's actually agreement within the parties. But it's also less convenient and more time consuming. So as you can see on the right part of the slide, that's an example of questions that you would be asked if you've made it clear that one of your parties is a company and the document corresponds to a Section 127 clause. Here, it's important for you to specify whether the company has a company secretary, whether the company director also acts as a company secretary, or the company has a company secretary who's a different person from the company director. This is all in the context of single director companies, by the way. And how you answer that will determine how the execution clause is structured. So you may be required to have the signature of two directors, of one director and a secretary, or simply of one director. And we provide all the necessary optionality and guidance through these questions to make sure you have the right execution clause. Next slide, please. The other way that companies can sign documents is through section 126. So that section provides that an authorized representative of the company may sign the document and bind it on the company's behalf. Generally, courts are quite flexible in the way that they allow companies to appoint representatives. So there's more than one way to do that. Some people use powers of attorney, which may take a little bit more effort. We provide the director's resolution authorizing person to act as agent for a company in order to ensure that the company appoints the desired authorized representative. What's really important for both parties when signing in this way is that they are 100% sure that the person who's signing on behalf of the company has the authority of the company, which means two things. Firstly, that they're not being scammed, right? This isn't just some person who's seeking to get the money of one of the parties or their corporate IP. And secondly, it also is a way of safeguarding that the person who's signing understands the intention of the directors of the company and any other people running the company, which will avoid disputes down the track. And finally, for both of these methods, e-signing is across the board allowed by the legislation. This was a change that was made during COVID times, and it's stuck around. Next slide, please. So yeah, this is an example of a section 127 signature block at the top, and then section 126 signature block at the bottom. And both of them may be correct, depending on the circumstance. Next slide, please. So how do partnerships and trusts sign documents? So generally, state partnership acts allow partnerships to be bound by the signature of any one partner, which means that any partner may act as the authorized representative, or like, the equivalent of that. But partnership agreements may provide certain requirements that are more specific than the partnership acts, and these also have to be adhered to. Partners may also by deed appoint agents to sign for the partnership, but only by deed when it's a partnership. Trustees may make decisions for how to use trust money according to the terms of the trust and sign documents based on those decisions. The same goes for attorneys under powers of attorney. But the reason why I talk about what they have the power to do and not do is that their authority to sign ultimately stems from the original document, whether that be a deed establishing a trust or a power of attorney document. And this is how courts will evaluate the validity of that action. And trustees are able to sign documents generally in the same way that companies or individuals would. The standard format for doing that is to insert the title of the trustee as ABC Proprietary Limited as trustee for, or ATF, the Johnson Family Trust. Next slide, please. Okay, what about deeds? For companies, it is the same as signing agreements. It really is that simple. They don't need to be witnessed. It may be common practice in many circumstances for signatures binding companies to be witnessed, but under the Corporations Act, this is not necessary. You only need to follow the same requirements that I laid out before, section 126 or 127 signature. However, individual deed signing is regulated not by the Federal Corporations Act, but by individual state acts, all of which have different requirements, which is why we have this notice that appears whenever you select an individual as a party to a deed. Here on the right, this is from the discretionary trustee, by the way. Queensland, Victoria, individuals may validly sign deeds on their own behalf electronically or without a witness. But in other states, it's different. So, that's something that you You can follow whenever you come across that notice, but I'll explain certain components of it, which is that, yeah, generally deeds must be witnessed when signed by individuals, whether in person or online. In Queensland and Victoria, they don't have to be, but it is common practice to do so anyway. What we've described, the process that we've described here of printing the document and applying wet ink signatures and then having someone witness and sign the document, that may be done with all the parties present together, signing the same copy of the document. It may also be done using separate copies of the document, which allow the parties to be in different rooms with a witness to each party signature present in the room with them. This is called a counterpart signing method, but it's important to note that counterpart signing has to be allowed by the terms of the document itself, and not all documents have that clause. So it's important when doing a signature through the counterpart method to know whether it's actually possible within the agreement. Next slide, please. All right. What about wills, powers of attorney, and statutory declarations? For those who provide specific guidance in the relevant documents, because the way they need to be signed and filled out from the very beginning is often described in the legislation and has to be closely adhered to, with the exception of powers of attorney, which we're gradually rolling out. Where a document is available for certain jurisdictions, but not for others, it is because the legal requirements for completing the documents may not be compatible with our platform. By which I mean, it may be that you're not able to e-sign a certain document at all when you're doing it in certain states according to their state legislation. And so we don't provide that facility for some documents, but we do provide it for others. Next slide, please. All right, let's jump into this. I think we are running out of time for questions, but I'll get through this section quickly. Next slide, please. All right, so we update our documents in accordance with legislative changes. The email on the right is one that we sent out recently regarding the family and domestic violence law amendments that were enacted at a federal level recently. So we do that for special cases where we're changing the substance of document and also our guidance about how it's being used. And we think it's particularly important in this case because, for instance, employers may be used to providing only 5 days of paid family and domestic violence leave. 5 days of unpaid leave, and now they have to provide 10 days of paid leave. And that could be a bit of an adjustment for some. So we've changed all of our documents to reflect that, and now we're letting you know what we're doing. You can see when a document has been updated, that's in the document description page. And in order to make sure that changes to a document have been incorporated into your own version, you have to generate your document again. Yeah, so there will be more instances when you will receive emails like this or find guidance that makes it clear that something has been changed. There was a lot of that both during the lockdowns and during the lifting of the lockdowns. Next slide, please. So how do we stay up to date? We subscribe to a range of newsletters and we're informed by various industry organizations, and we regularly look through notice boards where legislative and regulatory changes are announced. Our lawyers, documents team, and CEO regularly communicate about how documents can be replaced, improved, or updated. And it is through that set of procedures that we ensure that all of our documents are compliant with legislation on an up-to-date basis. Next slide, please. We also occasionally change the UX and UI of our documents. document section of our website and other parts of our website. These changes will not affect your saved documents. And please let us know on Intercom if you have any questions about new features that we are implementing. Next slide, please. All right, we'll also add and remove documents. So over the last year, we've added general and enduring powers of attorney for New South Wales, Victoria, and Queensland, personal services agreement, a deed of release and waiver, and ESG, which is environmental, social, and governance policy, an outsourcing agreement, and a copyright assignment. We've also removed some COVID and job seeker related documents for redundancy and incompatibility. We don't always remove documents. Sometimes we just change the way that they're framed. So for instance, we might change our COVID policy to a pandemic policy. And you can still access your saved versions of those documents, but we won't continue to provide support in regards to questions about those documents. Next slide, please.
Perfect. Well, thank you for that, Edwin. Now, I just wanted to go through how Lawpath can help. So Edwin has given us a very comprehensive overview of the document library and how you can use it for all your documentation. Now, we find that roughly 80+% of individuals and businesses can find it difficult to access legal services. They have a perception that it takes a long time. It can be expensive and complicated, and that's where the document builder really breaks down a lot of the complexity and makes it easy to understand and to get all these documents signed and completed and stored in the platform as well. So how Lawpath can help, we have our contract management system, which Edwin has walked us through today. We also have e-signature built into the platform that you can use to sign these documents, and they're legally binding. So again, it's a full contract management system, and then you can also email them to other people and store them as well. We do have personalized workflows, so around setting up a trust, hiring an employee and a contractor, collecting a debt, registering a trademark. There are a bunch of others that we do have as well. So they walk you through the direct steps and the direct documents that you do need to complete these actions. And then lastly, booking in legal consultations. So we do have a range of legal and accounting plans, which provide unlimited consultations on, on new matters. So you can get 4 pages of contracts reviewed with the lawyers on the majority of documents, and book these in at a time that suits you best. We have a legal health check as well. So on our website, you can run through the questions and different parts of it, and it will kind of rate your business, potential gaps that might exist, and what documents you may or may not need. Now, going back to the plans and the services. So again, the legal advice plan is our signature service, and we do provide unlimited 30-minute calls each month with our lawyers. So you can jump on whether it's a reactive matter or a proactive matter and get the advice that you do need. We do have live chat as well. So for basic queries, we can give you some advice on a more timely basis, whether you've got simple legal queries. And then again, like I mentioned, 4 pages of contract review where we can give you verbal advice and help you see if you've met the compliance for that document. Now, on the right-hand side, we do have an accounting plan, which does provide chartered accounting advice. Our friends at Pop Business run this one. So the lawyers and the accountants, they do speak to each other so that they're across your business. And on this one, we do offer an ASIC and ATO agent service. So if you do require company changes, such as a change in address, shareholders, change in your share structure, etc., these can be filed with ASIC as your appointed agent on your behalf. Now, I just want to highlight the accelerator program. Not only do you have access to unlimited legal calls for reactive matters, things that pop up from time to time, but we also have a dedicated accelerator program. You can see the 6 topics here around reviewing your business structure, reviewing your brand and intellectual property like trademarks, looking at your employment agreements and policies, supplier and commercial agreements, privacy and insurance policies, and then capital raising. So these are all topics where we can help you be a bit more proactive, depending on what your business goals are, and ensure all these steps are compliant and they're in the tip-top shape that they need to be. If you're looking to raise capital or sell the business, these will be important to get sorted and to get compliant as well. Now, one more thing is we do have a 120% tax deduction on Lawpath subscription products. So the 4 subscription products we offer on the screen here, our plans and also our virtual offers, they're all tax deductible at 120%, which means that you do get a bit of extra money back when you file your tax return from June onwards. So definitely keep this in mind, and we're more than happy to send an email with some pamphlets if you would like to read more into this, or send this to your clients as well. Now, today we are offering 20% off our legal advice plan. So if you've loved what Edwin shared and you wanted to get deeper into the documentation and get this reviewed by a lawyer, or also get some high-level legal advice, then please key yes into the chat. One of our team will reach out this afternoon. We'll walk you through the legal advice plan, the accelerator program, the 120% tax deductibility, and they'll get you booked in with your discovery call with one of our lawyers as early as tomorrow. Now we'll just pass it back to Edwin for Q&A. I believe we have 2 in the Q&A box.
Yes, and I encourage anyone else to submit questions of a general nature relating to the things that we discussed, if they have them, and also if they have any suggestions or any issues that they have about using the documents on our platform, feel free to submit those as well. So the 2 questions we have: what is the difference between a contractor and a subcontractor? This is an important question and sort of relates to what I was saying before about who are the parties and who should sign a document, right? So generally you have a client. Client is the one that the contractor directly services, right? Now, subcontractor is someone who contracts with the contractor. So there's an agreement between the client and the contractor, which is the main agreement. And then there's a subcontracting agreement, which is between the contractor and a third party. Contractors do this for all sorts of reasons, cost-cutting measures, as a way of allowing themselves to specialize while still providing a range of services. What's important to note is that subcontractors do not have a direct relationship, a binding agreement with the main client. So there's 2 agreements that link by requiring the parties to perform similar obligations, right? But the party that is on the leash is one in the middle. So the contractor is the one accountable to the client. If the subcontractor doesn't perform their obligations. Again, do not consider this legal advice relating to your specific circumstances, but that's the general nature of subcontracting. Can a trust deed be signed digitally when set up? So that depends on the factors I laid out before. So if you have 2 companies that are the trustee, beneficiary, or like settlor and trustee, who are setting up a trust deed, and it's only companies that are signing, that is, it is the representatives of companies that are signing the trust deed, then yes, they can be signed digitally. When you have individuals who are parties to a trust deed and they have to sign on their own behalf, it's different. Their signatures are regulated by specific state legislation, and it can get quite tricky. So unless they're in Queensland or Victoria, as is as is mentioned in that warning, then we generally advise that they sign in the same room with a witness by hand. That's the most reliable way to ensure that it's binding. Another question: do you have a dispute resolution clause in your library suitable for use in a professional services agreement? We generally don't provide specific clauses in our library that can then be inserted into particular agreements, because that requires a certain level of tailoring and specialization that amount to your circumstances, that amounts to the work of a lawyer providing legal advice to you. So that's something that you can access to a legal advice plan or marketplace. Having said that, we do have a bunch of services agreements that are effectively professional services agreements. And I believe they all have dispute resolution clauses. Some provide for mediation, some provide for arbitration, depending on the circumstances. And again, this is something that you have to consider when drafting the document, when answering the questionnaire. as to whether it's appropriate to your circumstances, or whether you'd like a lawyer to help you tailor them to your circumstances. We'll leave the chat open until a few more minutes, Ryan. Any more questions? What do you think?
Yeah, absolutely. We did get one question on the webinar recording. So as usual, we will upload these to YouTube by the end of the week. So definitely a great resource to consider. You'll see a lot of presentations from our lawyers, so Sam and Damon, and then obviously Edwin's presentation will be up there. So we've got one more question around stamping a deed, Edwin.
Sure. Unfortunately, this is not one that I am very familiar with, but if you, I'm sorry, I'm not sure, I correct me if I'm wrong, but you can ask that question also through Intercom, and we can provide you some guidance through that if you're a subscriber.
Yeah, fantastic. Well, again, thank you everyone for attending today's webinar. Like Edwin mentioned, I think this is a more of a legal question around the stamping of deeds in a specific state, which our lawyers can provide on the Intercom. So definitely jump on and do that. But if you have any last questions, you can key them in now. Otherwise, we want to thank you for attending the webinar and the presentation today as well. Fantastic. And I've just launched a last poll here as well. So we just want to gather some feedback on today's session, how you found the session, and if there's any improvements. Again, if there's any questions around documents that we may or may not have in the library, things that you want to see added, or any improvements to the platform overall, then you can definitely key it in